The signing of the Deep Offshore Act received support from the National Assembly, and it was promptly signed by President Muhammadu Buhari. What are the benefits of this act and how would it help check corruption in the sector? Professor Ladan, he is the Director General of the National Institute for Advanced Legal Studies, is our guest and will be answering some of these questions and more. Good to see you on the program.
Yeah, thank you.
Okay. With these developments, since they say the President is excited about signing it into law, what do you make of it?
I think essentially the signing of the amended Act 2019 in respect of deep offshore production sharing contract in relation to also inland basin is essentially commendable. And for two basic reasons. The President has every reason actually to be so excited about it, because first reason is that it is a fulfillment of his promise made during the 2020 budget presentation at the National Assembly, that he wants to fast track the amendment of this production sharing contract law, with a view to generating additional revenue for the nation to the tune expectedly of about $500 million US. The second basic reason as to why Mr. President is also justified in being excited is because it is also hopeful that the amount additionally to be generated in terms of revenue to the government coffers will also aid in the implementation of 2020 budget, particularly with regards to the infrastructure deficit gap of the budget.
Okay,
so these are two basic reasons.
Okay, let me come in here. Would you say it's about time? Some say it should have come long before now.
Yeah, I mean, it is true. First, if you go by the principal act that was amended and then assented by the President, on November 4th, 2019, the principal act itself has a commencement date of 1st January 1993. In it, the law actually clearly stipulates that it is actually subject to periodic review. The first or initial review is 15 years after 1993, which means in 2008, it ought to have actually undergone a review, but it was not done for reasons best known to some government officials and also to some industry actors or players in the industry. That's one. So if you also take the principal act that was amended, also clearly provides that after the initial 15 years, that is from 2008, there should be a review every 5 years thereafter. This was also not done.
But would you say the 5 years review is also enough, or would you say it's too short?
Well, it's not about whether the 5 years actually in the principal act will be enough or too short, but the truth of the matter is that neither the initial review was done, nor the second actually 5 years review was ever actually effected.
So now would the 5 years review be in order? Should it be extended or shortened?
No, I think the fundamental problem we're having actually is that really justified the amendment is that 15 years initial review was not done, plus 5 years thereafter was not done, making 20 years. So as at 2011, okay, 2011 from 1993, you discover that the reviews that were supposed to be done have not been done. And so it cost us, if you go by the projection of the federal government at this stage, $500 million actually times 11 years, which means we've lost about $5.5 billion US in the last 11 years for simply not reviewing the act. That's implication.
Are these figures recoverable?
Well, I'm not sure the intention of the amendment is to backdate the recovery of the losses. The idea is to set the record straight that henceforth we are no more going to allow ourselves to be subjected to such huge losses because actually of the ineptitude on our part and also because of probably actually some sense of negligence on the part of government actually operators and bureaucrats.
Now, talking about the oil and gas sector, how do you see this amendment impacting that sector?
Well, it is true that there has been some arguments from the industry players, especially the oil and gas actually sector players, that look, is going to affect investment, profile. Is also going to affect those that are intend to come into this particular sector of the oil and gas, production sharing contract regime. But the truth of the matter actually is that, these particular industry players have had the field for over 22 years. And the government and the people of Nigeria are the ones that have consistently been at a loss or at a disadvantage or to their detriment. Okay? So the economy suffered. And therefore, government could not use these surpluses to really address some infrastructure deficit and to invest also in social investment, sector. So both the economy suffers and the people also suffer at the same time. And at the end of the day, the industry players and some bureaucrats in the government, were the ones in the past 25 years that benefited, as few.
I have to come in here. Would you say this would fight corruption in the long run?
Yeah, I mean, if you look at the factors responsible for non-review, the initial 15 years by the Principal Act, who was responsible? Someone in the ministry or in NPC or in the actually both the ministry and NPC and other actors might be responsible. So here you have section 15, subsection 5 of the Constitution of Nigeria in one simple sentence says that it is the responsibility of the government to put in place, a policy to eradicate corruption and abuse of power, in Nigeria. Now, when you have a government that refuses to even engage in an initial review and another 5-year review, according to the Principal Act, then the only reason you can adduce to the non-review periodically required by the law is simply corruption and abuse of power, which section 15.5 says the state has the responsibility to eradicate it, and it was not done.
Something comes to mind. There's some school of thought that say the amendment is going to scare away investors. Is that true?
Well, again, it depends on the perspective and also the sector that you are coming from. If you go by the position of the government, you discover that they have actually every justification to introduce the amendment. And the amendment, out of 18 sections, only 2 sections were affected, Section 5 and Section 16. Section 5 simply, provides that, look, you need actually to provide a review of the percentage of calculation, of the royalty payable. And then the same section also says this is a new scheme of payment percentage, by oil and gas companies in the deep water and inlet basin actually production sharing contract, in Nigeria, for them to understand that there is actually going to be, a transparent scheme of payment. So first is the percentage calculated and then the payment scheme all under Section 5. For instance, when actually the new amendment says if the price of crude oil raises actually between $20 per barrel to $60 per barrel, you pay 8%. And then it says actually, if it actually goes beyond 60% up to 100%, you have another upward review, to 7.5%. And then if it goes beyond 150% per barrel, US dollars, you pay another 7.5%. As opposed to, the previous unamended and non-reviewed actually act, which put it at 8.40.
I'm going to throw in something into this mix right now. There's a lot of talk about the ease of doing business. Now, within the oil and gas sector, what does this mean? You're throwing in some numbers, and I earlier on asked you whether investors were going to be scared away. Now, with some of this, your explanation, how does this play into the ease of doing business in the oil and gas sector?
Well, in the oil and gas sector, already we have what we call the local actually content, law of 2010, and then we also have, the presidential, executive order on the ease of doing business.
Yes.
But in the context actually of this amendment, as at November 4th, 2019, what is clear is that you look at, the percentage, calculatable, under Section 5. And then the percentage also payable, in terms of royalty. It is now actually the responsibility of, investors to find a way of negotiating and renegotiating around these percentages of both the calculation and also royalty, that is payable. So this is actually open for negotiation and renegotiation. So there is nothing to scare actually investors away, but it is always actually possible to anticipate that once there is actually a radical review in a particular actually instrument, the expectation actually is that it will scare investors away. So investors have the opportunity to negotiate and renegotiate with government, but they need to understand the overall philosophy behind this amendment.
So to the investor listening, nothing to be scared of.
Well, actually they have, you know, all the needed actually time and opportunity to actually understand the new scheme, you know, of calculation and payment of royalties, so that they can actually negotiate and renegotiate.
Professor Taufik Ladan, Director General of the National Institute for Advanced Legal Studies, thank you so much for your insight into this topic. It was a pleasure talking to you.
Thank you. I'm grateful. Thank you.